Hello, folks. John Cantera, the double broker bounty hunter for the Freight Fraud Task Force. Welcome to the Tic Toc Diner. We're going to talk a little bit about fraud today, but really we're going to be digging more onto the compliance side. We're going to be talking a bit about MOTUS and some of the issues that have been going on there, as well as, well, it's been a month since the Montgomery decision. Has the dust settled? What is happening with brokers these days? Now that Montgomery is out there, and hey, let's face it, we're all worried about it. So let's see what is going on. Please don't forget to check out the Double Broker Bounty Hunter store. We've got the coffee mugs out there currently. I'm working on shirts and hats, but logo items for the Freight Fraud Task Force, Tic Toc Diner, and the Double Broker Bounty Hunter are out there. Please be sure to check that out. Go to my website, vigilanttransport.com, and you can get to our store. With that being said, let's get things going. I'll put that. Geez, I just put up the flyer. It helps when I actually run the startup sequence. You got to love these things when you go live.
For the Freight Fraud Task Force, welcome to the Tic Toc Diner Podcast, where we serve up freight fraud with a side of prevention. Grab a menu and have a seat. Your server will be right with you. Here is your head chef and host, the Double Broker Bounty Hunter, John Cantera.
Nice little soft jazz in the morning. Keep things calm, keep things straight.
That's the most sultry entry I've ever had on a podcast.
Hey, you know what? We want to make it a nice, relaxed feel. But hey, you know, the subject matter is really important, and a lot of brokers out there are kind of struggling right now with what's going on, which is why we have Brandon and Drew here. Brandon, why don't you go ahead and introduce yourself?
Hey, everyone. I'm Brandon Wiseman, president of a company called Trucksafe and a partner with the Childress Law Firm, both in Indianapolis. We help fleets with DOT compliance. Been doing it for about 20 years. And yeah, that's me.
Pretty straightforward. And we have back with us, Drew. Go ahead and introduce yourself.
Yeah, Drew Wilder, Vicarious Liability Risk Management. We assist shippers with insurance, vetting compliance, setting up proper SOP and vetting standards, and can assist in cargo claims if needed.
Well, guys, we have a ton to talk about. You know, here we are a month out from the Montgomery decision that SCOTUS had, and we are definitely seeing the ripple effect going across the industry when it comes to what carrier or what brokers have to do when it comes to vetting carriers. Now, the big question that's out there is, you know, what constitutes a safe carrier? And normally we would look towards the federal government to give us that answer. But, you know, the data coming out of the federal government these days is not that great, especially when you look at the new system out there, MOTUS, which its launch has been, well, shall we say, less than stellar. Let's go ahead and start off with the Montgomery decision. Drew, just a quick summary for people who are watching who may not have any idea what we're talking about. What's going on with the Montgomery decision?
Well, you know, at this particular point, you know, shippers and freight brokers especially are responding to how they go about, you know, vetting, you know, motor carriers and establishing a paper trail that establishes that they, you know, did their due diligence, you know, in the event that they're brought into a lawsuit, because now they could actually be, you know, held accountable if a loss occurs.
That accountability is the big question as things move forward. And as we look at that accountability, as I said, you know, a lot of us look towards the Fed, and that's where compliance comes in. Yeah, I don't know what the heck's reliable these days. You know, I was helping my employer try to vet a carrier the other day, but the different systems that are out there, CAB, RMIS, MCP, Highway, they may show something different than what MOTUS shows. So what then becomes the source of truth? Brandon, any thoughts on that?
Yeah, I mean, it's certainly bad timing to have this decision come down from the Supreme Court, and then all of a sudden, with this renewed focus on the importance of the data when it comes to vetting motor carriers, to have at the same time a rollout of a completely new registration system by the DOT that, by all accounts, is struggling pretty mightily right now. I mean, it's been a couple of weeks since it was launched, and every day I'm having carriers call me and tell me that they're having trouble logging in. I have brokers and shippers calling me, telling me that the same things that you're seeing, John, that the data on the system is not matching up. So just terrible timing, number one. And so it makes it very hard, as you say, to trust that data, which is a big problem. But I guess I would consider it one layer of the problem, but I don't think it's the deeper problem that we as an industry are going to have to wrestle with now and then well into the future, which is even assuming we get the data feeds back and we can start to rely on the accuracy of the data coming through, I just don't trust that data that exists to tell us whether a particular carrier is safe or not. Are they accident prone or not? In fact, the FMCSA itself has said many times and publishes on its website that the data was never intended for that purpose and doesn't do a good job of serving that purpose. In fact, if you look back at some prior studies run by the American Transportation Research Institute, I think back in 2012, they looked at like the 7 basics, the categories that carriers are scored in the CSA system. And they found that one of the basics, driver fitness, had an inverse correlation to crash risk. In other words, carriers with a worse driver fitness score were less likely to get involved in a crash than carriers with a better driver fitness score. And that's the data that we're talking about using to vet a motor carrier, one where there, at least at one point in time, for one of the factors, there was an inverse correlation to crash risk. If that sounds crazy, I mean, it is crazy that's going to be the system that a lot of folks are going to be using to try and decide, is this carrier that I want to haul my freight safe or not? It just doesn't do that. And so I think the bigger question that we need to be asking is, I think we need to take a real hard look at what data we have available, what it's good for, what it's bad for, and more than likely, what systems do we need to put in place to do a better job of what we're asking it to do.
I was just about to say that. So well said. No, it's a very complicated issue. I've looked at some of the different things that are going on in Modus. I know I did a post earlier in the week and highlighted 6 very specific things that people have been coming to me about. The first one, I think, is probably the most emergent: insurance filings. There's a lot of reports of insurance filings being submitted by insurance companies that are not getting into the Modus system, where if someone's got a renewal going through, the new filing's not showing up, and now the carrier is being put at risk of being taken out of service for not having insurance. Have you run across that yet, Brandon?
Yeah, for sure. And then also for new applications, for example, a lot of the new applications either aren't getting processed through the system, or, to your point, the insurance piece isn't landing on the account, which is then not allowing them to actually get approval of the final authority, and then they're placed inactive. So yeah, it's a big problem. And, to some level, this type of thing is somewhat expected anytime there's any kind of big new changeover in IT systems, especially when you're talking about government systems. But, given how long the agency has been working on this system, we had hoped that it would be minimized to the greatest extent possible. And it turns out that it's not, unfortunately. And so carriers are paying the price for that, either because they are being shown as inactive in the system and then they lose freight because of it, or they can't get the authority to begin with to get up and running. So yeah, I mean, there's no sugarcoating it. It's a big problem for a lot of fleets.
Another one of the ones that are out there along the same vein And I did not know this until a good friend of mine, J.R. Elrod, um, uh, Frozen Reach. You got to check that book out if you haven't already. He's going through an issue right now. His insurance is renewing. However, he got reclassified as a hazmat hauler, which he never hauled hazmat before. He got reclassified by Modus as a hazmat hauler because he happened to have on his MCS 150, he had machinery checked. And machinery assumes a combustion engine or some kind of a motor or something where you do have some trace hazmat fluids in there, which triggers that class 9 hazmat requirement. But because of that, he wasn't able to find an insurance provider who was going to write him a new policy.
Yeah.
I'm hearing a lot of stories about that.
Yeah, I mean, obviously, that's a big problem. If the system is auto-triggering a hazmat designation and the insurance filings that come along with it, just based on what type of cargo you're saying you're hauling, because I mean, you can envision a scenario where you're hauling machinery that doesn't have any fuel in it, or to some extent, I see that there's other things in machinery that is hazmat besides the fuel. Seatbelt pretensioners, stuff like that can be considered hazmat. But the point is a good one, which is we shouldn't have a system where just identifying the type of cargo, the category, the high level categories of cargo that you're hauling should trigger any kind of filing. It should be based on the specific types of commodities that actually implicate those requirements. If you say you're hauling fuel, then I understand, flipping on those additional requirements. But yeah, I mean, that's a mistake if that's how the system's going to treat it. And yeah, I mean, what are the insurers to do? Now, all of a sudden, they're seeing the system characterize them as a hazmat carrier, and hazmat carriers have different insurance filings. So the insurer has to do what they have to do with the data, what the data is telling them to do with it. So
again, it goes back to source of truth. What is accurate, what is not, and brokers are really struggling with this these days. We really don't know what we're trying to vet, or what tools we should be using when trying to vet. When CAB, Modus, RMIS, they're all showing different data in trying to do that vetting. Would a broker then add liability to themselves by relying on a specific system and the data just may be wrong flat out?
Well, even putting aside these Modus transition and data quality issues, I think just relying on a system without understanding what the system is actually telling you is you're hiding behind something that's not giving you as much cover as I think it's giving you. You really need to understand the underlying data that the systems are using and what they are actually saying about the fleets that you're choosing to do business with. Because if I just rely on a system, I have no understanding whatsoever about how it works or how it rates carriers, and I'm just making yes, no decisions based on what that system is telling me. Have I really exercised reasonable care in that? Maybe, but maybe not. I mean, that's the issue here with this decision coming down, right? I mean, that type of question, whether it was reasonable for me to do that or not, is going to be a question that's decided by a jury in most cases. It's a factual question. And that's the big fallout from the case, is that brokers no longer get the procedural shield of what's called F4A preemption that they had enjoyed in some of the country, not all of the country, about half of the country, where they could get out of the case early on. It's like a procedural exit ramp where they get out very early on in the case. They don't have to deal with the factual question of whether the system they use was a reasonable approach to carrier vetting or not. They just never got that far in the case. Now, with that procedural exit ramp completely stripped away from them, there's a much greater chance that they're going to find themselves that far into litigation, and they're going to have to answer that hard question of whether they acted reasonably or not. And unfortunately, until we start to get some development in the case law out there, and even with that, it's still going to be hard, because it's going to be a case-by-case basis decided by the jury in most cases that are reviewing the facts of that specific case, and they are going to be the ones that are deciding whether that was reasonable or not. So it's kind of a gamble, really, regardless of what you do.
Yeah, I 100% agree with you that gamble is going to be something that all brokers are playing for a very long time. I dread to think what a new broker is going through right now, trying to start a new brokerage. One, trying to figure out what kind of systems they may need to try to do vetting, or if they're brand spanking new and they have to start off manual vetting, how do you set your process up so you have something reliable and defensible should you wind up in court? Drew, I know you've been following this Montgomery thing fairly closely. I know you've got a bunch of opinions on that. Hit us.
Well, I start with what Brandon was saying when it comes to trusting the data and the maybe the third-party compliance companies that you may choose to to deal with. I think it really starts with, and this is what I say to people, when it comes to your vetting process and your contracts, et cetera. I want to know whether or not they've employed the services of an experienced freight transportation attorney, similar like Brandon, for instance. It kind of starts there, because you want to know, in the event that you get pulled into something, you want to know that you've done the best you could when it comes to your vetting and relying on the data that you utilize to make those decisions. One of the things that I've noticed over the last month is that there's been a lot of talk about what could possibly happen moving forward, now that there's that exit ramp isn't available, depending on what part of the country you're in. And so my thought is that, well, there's been parts of the country where it hasn't been available, and so I think that people that work from that angle or in a better position than people that didn't. With that being said, these lawsuits are going to happen, and as Brandon said, there's going to have to be some case law established to see how this thing plays out. But when it comes to, say, for instance, plaintiffs' attorneys, what are they going to do now? Are things going to be looked at? Say, for instance, what role did the compliance company, the third party, play? Okay, in the process, what thing, promises did they make? It really comes down to, I believe, having a vetting process that's thorough. Did you, and I would also look into, it's not so much of, okay, what the vetting platform, says they're going to provide, but again, where's the dollars going to come from in the event of a suit? Because it's got to come from somewhere, right? And so, I think one of the things that would help people when it comes to, relying on this data or a third-party compliance company is, having a conversation with that provider's insurance agent or broker. Okay, does their agent or broker know exactly what it is, the service that they're providing to you? What does their policy cover? All right, what are their requirements? And if you have a party that's providing services to you and they're not liable for anything, then I would say, why use them? But again, that comes into having a detailed plan as to how you're going to not only vet motor carriers, but how you're going to vet the third-party compliance platforms out there that you're utilizing. It doesn't matter whether it's safety, whether it's insurance compliance, et cetera. But again, I think that starts with having a comprehensive deal, SOP, and employing the services of a qualified freight transportation attorney to get that process started. I think it starts there. I don't see any other way that you could do it. And another thing is that I believe that the more repeat carriers that you utilize, that's going to help a lot as well.
So we're back to building relationships again.
Yes.
Which we have gotten away from over the last 4 years. This industry has become very transactional with spot freight moving in mass numbers. I cannot wait to see relationships really come back into this space. I know when I was dispatching, relationships are how I got more than half of my loads. I hated relying on a load board, but knowing who you're working with, to me, seems to be the best shield that you can have out there. There has to be a level of trust, but then you still have to have the documentation behind it to justify that trust, to quantify that trust. And that's where I think a lot of brokers are really struggling at this point. How many brokers do you think that are out there, rough percentage, are ready and are properly prepared for this? I mean, are we talking like 25%, 50%? How many brokers are really out there on the right path here?
I couldn't really say. I will say this. As a result of the pandemic and the spike in double brokering that occurred, and just the activity on LinkedIn, just watching that, I felt like that the industry got caught flat-footed. Probably only, and I don't know this, but maybe, I don't know, 20% may be ready. And when I say ready, we're probably doing things right in the beginning, because again, as Brandon talked about, when it comes to that exit ramp, it was only provided depending on what part of the country you were in that the loss occurred. And so, if you work from the thought process of, I don't know where this loss is going to occur, therefore I'm going to look at this in respects to there may be no exit ramp, and you work from that angle, I think that there were a small percentage of people that were working from that angle, but the majority weren't. Like, say, for instance, and you saw this yourself, John, I'm pretty sure, Brandon, you did as well. Just looking at vetting insurance, right after we came out of the pandemic, you would see on LinkedIn on a regular basis where someone would have a cert that they were vetting, and they would be asking everyone for their opinion. Well, the cert didn't even have a certificate holder on it. No telling where it came from, no chain of custody. They were always making these phone calls to, at least they would say, okay, I made a phone call to the insurance agent or insurance broker to verify this. Well, okay, but no email was sent. So in the event that you say, okay, you wanted to rely on the data that was provided to you, you have no paper trail. You just have a he said, she said. And there's a few court cases that address this where, the court had to decide who was credible, whether the motor carrier, shipper statements were credible, or whether the insurance agent's statements were credible. And so, for me, it's been a situation of the industry just got caught flat-footed, even post-pandemic. Same things happening now, and this, John, about me. I'm just not a fan of speed, right? Freight's got to move. I get it, but I think that's the bigger issue. People are just trying to get things done faster than they can, and I don't think there's ever been a real honest conversation with shippers from motor carriers and freight brokers about two things. One, how much did it really cost to run a trucking company, and how much time does it really take to do proper vetting?
When I was dispatching, I know when I was introducing a carrier I was representing to a broker for the first time, I've done the vetting process as fast as 5 minutes.
Right.
Are those days now gone?
They should be.
Yeah.
But I worry that they're not going to be, because everybody just, as Drew mentioned, everybody just wants an easy button, right? And a lot of these third-party vetting platforms, and there's going to be, no doubt, there's going to be a surge in these platforms. Folks from within the industry, folks from without the industry who see this as a business opportunity for them to make some money. And too many brokers are going to do what they have been doing, which is to rely on those platforms as the easy button. The system gives them a green light or a red light. And if that carrier got a green light in the system, I'm just going to tender them some freight. And the problem, of course, is that, you know, you can see how that goes badly. You tender that freight to a green lit motor carrier. Carrier turns out to be not all that great from a safety standpoint for many reasons. One of which I already mentioned, which is that the data that those systems are ingesting aren't great at telling you whether the carriers are safe or not. And so that carrier goes and kills somebody or seriously injures somebody. You find yourself as a broker in that lawsuit and you're trying to defend yourself. And the question's going to be, okay, what did you do to vet the motor carrier? Well, we used system X, Y, or Z, and it gave us a green light. Well, what did the green light mean? I don't know. It gave me a green light. Well, what did you do to understand what the green light was telling you? I mean, what causes things in the system to have a red light? And if you can't answer those basic questions about what the system is telling you, I mean, I don't think you survive that type of case. I don't think it's reasonable for you just to rely on these systems without you doing some basic diligence yourself and understanding what the systems are telling you and understanding what the underlying data that they use is useful for and what is not useful for. I think you have to use your brain as much as we don't want to, a little bit, and in addition to these tools that exist. These are just tools that you can use to help you exercise your own reasonable care and doing these things. So I think Drew's exactly right. I mean, brokers, if you aren't already, a lot of brokers have already done this. As you said, Drew, the brokers in the country that have operations all over the country, they couldn't afford, even pre-Montgomery, to rely exclusively on the F4A preemption as a defense. So they had already taken steps to bolster their carrier vetting programs. But if you haven't already done something like that, you need to, at the start, set up the foundational things. You need to put together a written policy that says how you're going to handle these things. You need to make sure it's workable for your operations. You need to identify what systems you're going to look at. You need to identify who's going to look at them, how you're going to document these things. And you need to follow through with them and not deviate from those policies. And I think there should be some level of education to the folks on the front line that you're expecting to make these decisions in trying to understand the data that's going into it. I mean, this is going to sound like a sales pitch, but that's one of the reasons why I wanted to develop training content on that topic specifically. One of the things we do at TruckSafe is do training for the motor carrier industry. We've done that for many years. But what I wanted to put together after I saw Montgomery come down was a course that was specific to brokers and shippers on how to understand the data that is out there on motor carriers and what it means. What does an out of service rate mean, and how is it calculated, and why does it matter how much inspection activity that carrier has, and that type of stuff. That kind of granular level detail that I think is important when you are assessing whether this carrier is likely to be involved in a crash or not. So that's something we offer for folks that are interested in it. But I think that educational piece is something that I don't hear a lot of people talking about, but I think it's pretty important.
Brandon, you're absolutely correct. It's extremely important. One of the things that I also feel like that's important, at least I used to do when I was, former safety director, is that, we talk about the safety element, and that's extremely important. But also, if a crash occurs and the motor carrier isn't properly insured, or that policy has lapsed, they're unqualified to operate. Period. And so, that's another piece that I think people need to focus on, because, there are platforms out here now saying that, they're pretty much guaranteeing that if you use them, that the coverage is always going to be live and they're going to know immediately. Well, okay. And it goes back to what Brandon was saying. Well, if they're telling you that, and they're not the broker or insurance broker, insurance agent of record, then they have no control over that. They're getting this information from the insurance agent or broker of record. Okay, so I would want to know, and I've talked about this before, John. I'd want to know what that agreement between those parties look like, because if the agreement says that this commercial insurance agent or insurance broker is going to provide prompt notice, they're going to be able to defend that. Okay, so what does the notice mean? Does it mean that if the policy lapses at 12:01 a.m., that the third party system is going to be updated at 12:05 or 8 a.m. the next morning? What does that mean? So again, when people say that, you really need to know, dig into the details and understand, okay, how are they getting that data? When exactly are they going to get it? And what, liability has the insurance agent or broker that they're getting this data or they have this agreement with are taking? Because it's like this, people talk about transparency. Well, if there's no accountability, there is no transparency. The people have to know that if something goes wrong, they're going to have some level of accountability. If they don't, then, I don't know that you have much. The other thing I would say is that, and I would say this to shippers and the freight brokers, because they have, insurance policies as well, whatever they may be, take some money as a line item each year when you're renewing your policy, add some dollars to it, whatever that cost is. And you could get that from your insurance agent, because you don't want them to just come in and deliver you a fancy binder with some numbers in it and say, hey, you saved this amount of money. Great. You want them to spend a few hours with you going through the policy, have a list of questions that you've already, laid out, because, you want to know what your due diligence requirements are. You want to know what the exclusions are, et cetera. And I know people talk about, okay, read the policy. Yeah, that's important. But if you got to take the time to figure that out, then what are you paying your insurance agent for? That's their job. They should be making sure that you know exactly what's covered, what isn't covered, and what your due diligence requirements are. But I would take it a step further. And the reason I would pay them to do it is that I don't want, if for some reason I want to say that, okay, they failed me, I don't want them to be able to come back and say, well, you know what? We was just operating like a freight broker, arranging the transportation. We were arranging the shipper. I want to be able to show that there was a special relationship created between me and that insurance agent or broker. That could go a long way, because depending on the situation, and Brandon knows this, there are court cases out there that clearly have held insurance agents or insurance brokers liable if there's a lapse in insurance or there's a policy dispute. So those things, people should do those. I don't think they should. I know they should. They should definitely do those things, because you don't know when a lawsuit is going to occur, and you don't want to. People just need to be held accountable.
Well, we talking about insurance. Most freight brokers getting into the business, to get your broker authority, you only need to have the bond. Well, once you have that BMC 84, BMC 85, you're pretty much good to go. Well, now you add in liability. You have to have some kind of liability coverage, because let's face it, the brokerages are now the deep pockets.
Right.
Okay, the brokerage and shippers.
Right.
They're the deep pockets in these types of cases. So we know plaintiffs' attorneys are going to be going after them, and going after them hard. So are we seeing a trend across the industry where brokers are now looking into liability insurance, or those who already have liability insurance are increasing their coverages? What's the insurance market look like right now?
Good. I wouldn't know that. All I would say is this. I do know that even prior to the decision and even prior to the pandemic, there were, insurance brokers, not insurance brokers, but freight brokers that did have, contingent coverage, et cetera. But a lot of them did not know what their due diligence requirements were. So if you don't follow those due diligence requirements, coverage may not trigger. Okay, so so that's important. Whether you had it before or whether you got to get it now, those questions should be answered. The other thing that I didn't add is that I know that all freight brokers may not be able to do this, but just like you go out and you hire experienced salespeople and operation people as well, I think freight brokers now need to take a hard look to see whether or not, can I have in place a dedicated compliance person? Okay, depending on the size, maybe a compliance team or compliance person. Having that dedicated compliance person doesn't take away from a third party being able to provide services, because that can be important as well. However, someone that is in charge of getting the freight moved, the quote, etc., and vetting the motor carrier, I just don't think they're going to do as a great a job as the person that they have one job, and it's to vet that motor carrier. Because the person that has that only job to vet that motor carrier, they don't have to be concerned about whether the load moves or not. They have to do a good job, but they don't have to be concerned about whether it moves or not. They're not going to be rated or reviewed on whether they should be rated or reviewed when it comes to performance reviews on whether the freight moved or not. They should be, reviewed and promoted or given raises based on the job they did when it comes to vetting. It's up to the freight broker or the shipper to override their compliance person. I wouldn't do that, but it's up to them to do that. But I just feel like that if you're going to be better off. It comes at a cost, but you're going to be better off if you had a dedicated person, because this is what they're doing every single day, and that's all they're doing. So they're going to pick up on subtle clues that those individuals that are moving the freight may not.
Yeah, I mean, that's a good point. The conflict issue is huge because now brokers are going to feel the pain that motor carriers have felt for years. I mean, this has been a huge problem for motor carriers, right?
Right.
When you've got
Right.
like driver recruiters
Right.
who are also responsible for driver qualification, there's
Right.
an obvious conflict there because your
Yes.
pay is dependent on seating drivers.
Right.
And so you are incentivized to seat drivers regardless of what their qualification history might look like. It's a bad look all the way around.
Right.
Brokers are going to have something similar. They have had something similar. They do even more in the spotlight now.
Right.
So yeah, I mean, it's a good point. You gotta acknowledge those things for what they are and how they look. I mean, they look bad, and that's the type of stuff that's going to be exposed in these types of lawsuits. I mean, if you're in that position where your folks who are getting commissions based on the freight that gets moved are the ones that are making the call on whether to move the freight with a particular carrier, the optics of it just look terrible. And you're going to have to explain that in the litigation, and it's just not going to play out well for you. So those are the types of things, the foundational things about your structure, how you've got this operating, that you need to be thinking through right now if you haven't already. And you need to get them cleaned up in a written policy that's defensible, that's been reviewed by legal counsel, and go from there.
Now, we are starting to see the different state tort cases finally come to pass. We know that brokerages are getting called in as defendants and being added to cases. But shortly after the Montgomery decision, we saw Home Depot as being removed as a defendant on a case in Texas. Are you guys familiar with that one?
Generally, yeah.
Can you walk through that real quick, Brandon?
Well, what I don't know much about it. What I think I know is that the brokerage or the shipper was dismissed for lack of any allegation whatsoever that they didn't exercise reasonable care in selection. So it wasn't a decision on the merits of whether a particular vetting regime was reasonable or not. It was just saying, hey, we're not going to swing this too far the other way and say that a plaintiff can proceed in a case against a broker or a shipper without any allegations whatsoever that the vetting that was in place was deficient. You still have to allege in your complaint that the broker or the shipper had a duty to exercise reasonable care in selecting the motor carriers. They breached that duty by X, Y, and Z. So there's a baseline. There's still a baseline level of pleading that you have to do as a plaintiff to survive that motion to dismiss stage, but that's a very low bar. And from what I could tell from that case, the plaintiff hadn't met it in that case. But I don't think that case is all that instructive to the main issue, which is going to become most prominent, which is what does it mean to act reasonably in your carrier vetting? I don't think I've seen any cases get that far yet. We wouldn't have, right? Because we're only a few weeks out from Montgomery. Many of those cases had been held in abeyance pending resolution of this Montgomery case. So now the ones that had been held will proceed. And maybe a lot of them get settled because maybe a lot of the brokers or shippers in those cases were banking on the court coming down with F4A preemption in their favor. And now when that's off the table, maybe the numbers game is looking more attractive to them. I don't want to have to, pay all of the defense costs that are going to go into the full discovery that's going to be had in this case, and then the potential negative outcome if we end up trying this to the jury. That's just a lot of unknowns that you're going to put yourself through as the broker or the shipper in that case. So I think we're going to see a lot of brokers who are looking at that closely, and they're deciding that the risk is too great, the cost is too great to proceed in the cases, so we're just going to settle. And so I think that's going to drive up the settlement numbers on these types of cases, which in turn is going to have an impact on insurance premiums for the type of broker insurance products we've been talking about, stuff like that. I have no doubt that that's going to be the outcome.
What really stuck out in my mind about the Texas case with Home Depot is the term passive shipper. I saw that term utilized often. What constitutes a passive shipper versus an active shipper when liability is trying to be determined in such cases?
I don't know what the court meant by that. It's not a particular legal term of art that you'll see uniformly across the board. I could guess what the court means by that, but yeah, it's not like it's some kind of a standard that you see employed in all of these different types of cases where if you're a passive shipper, you somehow get out of the case automatically. It's not like a get out of jail free type card. So yeah, that's kind of how I view it. I don't know exactly what the court meant by it.
Hey, Brendan, I don't either, but I have in years past heard the term used, sophisticated shipper, right? And my understanding of it was simply this. The person that occasionally is moving freight, out of their garage, not a lot, they were considered to be an unsophisticated shipper. Someone like a Home Depot, etc., big guys or, freight brokers, they were considered to be sophisticated shippers because they were moving freight on a regular basis. So they should have had systems in place to understand, the compliance and things of that nature. Say, for instance, I'll just use Boeing, for example. Boeing operates as an airplane manufacturer, of course, but they also are a sophisticated shipper. They're moving a lot of commodities across these highways, right, on motor carriers, but they also operate a trucking fleet. So for someone like Boeing to say, just use them for example, to say that they didn't understand kind of how trucking operates when they actually own a fleet is my understanding.
Yeah. And in that sense, the sophisticated language to me goes towards what is the reasonableness of this particular shipper. Exactly. What are we judging them by? Should they have known that they should be vetting these motor carriers and that type of stuff? Another way that I could also understand potentially the passive shipper versus some kind of an active shipper language would be a slightly different tweak on that, which would be to say, this is going to get into the weeds and I apologize in advance. But negligent hiring is the type of claim that we're talking about when we're talking about the Montgomery case. It's a distinct cause of action that a plaintiff could bring against a broker directly, saying, you broker had a duty of care. You breached that duty by not acting reasonably in your vetting procedures, and you're liable directly for your own negligence.
Right.
That's one way you hold a broker liable.
Right.
But another way, a different way that you could hold a broker liable is to say, just by nature of the relationship that you had with the motor carrier and how actively you were involved in their motor carrier operations, you are liable by virtue of that relationship. That's called vicarious liability. It's the same liability that a motor carrier has for its driver's conduct. When a driver gets involved in an accident, the motor carrier, even if the motor carrier did everything right, they are vicariously liable for that driver's conduct by virtue of the employment relationship they have with that driver. It's the relationship that leads to their liability, not their direct negligence. And we have that same thing potentially with brokers as well, where you could run yourself into a situation as a broker where you become so involved in the motor carrier's operations. You're directing the drivers, you're contacting the drivers directly, you're dispatching them, you're checking their hours of service, where a court could say, and a plaintiff will argue, that you essentially became the motor carrier. You were so actively involved in their operations, you are the motor carrier, and as a result, you are vicariously liable for the negligence of the driver by virtue of that close relationship. And so that's always been a potential avenue of liability for brokers, and it still will be now. So my point is, maybe that's what the Texas court was talking about when they're talking about a passive shipper versus active. Doesn't really matter to me. But the counseling point for brokers is, you don't want to swing this pendulum too far the other way.
Right.
One way you're swinging it and you're not doing anything to vet the motor carrier.
Right.
But then you swing it too far the other way and you're getting so involved in the motor carrier's operations that you essentially become the motor carrier. And that leads to liability in a different way. So you're almost damned if you do, damned if you don't. So you need to find yourself somewhere in the middle where you are acting reasonably to vet the motor carriers that you're going to tender freight to, but you're not controlling them in a way that makes you essentially an employer, a joint employer of the driver that's hauling the freight.
Yeah.
I think that leads right into a great question that Vedran offered here. Do we think that shippers or brokers actually auditing drivers, not just motor carriers? Should brokers get into the driver qualification a little bit more?
Yeah, I mean, that's exactly to my point, which is I would caution you as a broker not to go to that level of depth, because once you are qualifying at the driver level, you're looking an awful lot like a motor carrier, the motor carrier that has the legal obligation to do those things.
Yep.
And the slippery slope, right? You start doing that, now all of a sudden, let's just take over the dispatching too, and let's just take over the monitoring of the hours of service through the ELD data that we already have flowing to us anyway. Let's just take over all of that and have that level of visibility into the individual driver's conduct. I worry that pushes you too far the other way, and you run the risk of being deemed a joint employer of that driver, and then your liability just flows that way instead of through any kind of negligent selection type claim.
So the broker should stay focused, in your opinion, then on the carrier company and whether or not they are compliant as a company.
In my opinion, yes.
Brandon, if you remember, I know this was before the pandemic, and I haven't followed the case. I just briefly heard about it. It involved Convoy that was based out of Seattle. And I know that like right before they sold or whatever they did, there was, I believe, a fatality accident that they were brought into. And what I briefly know about it is that they were alleged to have had employees for Convoy training motor carriers on how to do safety and things of that nature. At least that's what was alleged.
Mm-hmm.
And so those type of things can get you in trouble when you're the freight broker and you want to, like what Brandon was saying. But from what I understand, I don't know this to be true, but from what I understand, some of the folks involved really didn't have the experience. Another case that I heard about a few years ago involved FedEx, and I believe it was a fatality accident in New Mexico. And this was like an owner operator, or a smaller trucking company, because FedEx uses motor carriers that may have 4 or 5 trucks with FedEx on the side of them. And it was determined that there was some I guess the driver was unsafe. There were some equipment issues, but I believe it was determined that FedEx, there were things that they should have done or not done, and they didn't do. And so, that kind of, I believe that plays into it as well a bit.
Yeah, it's a cautionary tale to
Right.
folks that aren't getting the full picture here.
Yeah.
You want to do your diligence, but you don't want to become a motor carrier.
Right.
If you're going to act as a broker, do the things that brokers do, and do them well to the best of your ability. But don't sneak into the realm of doing the things that a motor carrier is expected to do and becoming a motor carrier. Because yeah, I mean, you're right. There are court cases out there. There are also FMCSA decisions where the FMCSA looks at it and says, wait a second, you're only registered as a broker, but you're doing things that look like a motor carrier.
Right.
And so why don't you have motor carrier authority? And why don't you have driver files and all of this type of stuff? So you just got to be careful. You got to think through all of these different nuances. And again, going back to what we've said over and over, make sure you are structured appropriately, and make sure whatever plan you're going to put in place is defensible, and then execute on it.
So, I know there's a privacy issue with brokers collecting copies of a driver's CDL. And I know there are a lot of brokers that are hesitant to do that, but there are a lot that say, hey, I want to make sure this guy's not running off of a non-domicile or something along those lines. Would that then be encroaching in becoming a motor carrier, as you were pointing out, as something to that level, or trying to get the VIN numbers of the trucks that are going to be used and trying to match that against an insurance policy?
You're not going to find a bright line like we would like to see a bright line where you say this is too far or this is not far enough. So yeah, I can't say whether getting the driver's CDLs is in and of itself. It's probably not in and of itself evidence that you are a motor carrier, but it's going to be one of many things that's going to be stacked up against you in that type of case, whether it be by the FMCSA or by the plaintiff's attorney to argue that, look, you were acting like a motor carrier. Getting CDLs, vetting motor vehicle records are things that motor carriers do. And so the more evidence you have like that against you, the worse off you're going to be. So I wouldn't draw a bright line on it, but yeah, the more you do stuff like that, the more you are exposing yourself to that side of the equation. And not to mention the privacy thing you noted, which, there are all kinds of federal and state laws governing, Fair Credit Reporting Act, for example, that govern what kind of disclosures you have to make to drivers and what kind of releases you have to get from drivers to run those types of consumer reports, like motor vehicle reports and stuff like that. And if you don't have those things and you are getting copies of their motor vehicle reports, then you've got that completely separate risk that is a significant risk in and of itself. So.
Okay. Well, I know there's, forgive me, Drew, here at the task force, we recommend to brokers that they identify VIN numbers of the equipment that's being used and pass that on to the shippers and for fraud prevention purposes. Do you think that recommendation blurs the line for a broker, or is that reasonable?
Yeah, I think, two things. I think VIN numbers, in my view, is a little bit different because, number one, that comes through in like even the public data that you're getting through the FMCSA system anyway. You can see VIN level information on the motor carriers that you're getting freight from, and just getting the VINs for purposes of fraud prevention and stuff like that. I mean, you also have to look at for what purpose are you getting it? In that case, you're getting it for fraud prevention. You're not getting it to make sure that the truck is properly maintained as a motor carrier would or something like that. So the purpose of the data is also important when you're looking at what is the amount of data that we're getting. So I would say, yeah, that doesn't concern me all that much, as much as like getting the CDLs and running motor vehicle reports and that type of stuff.
Whew. Okay, I feel better now. Yeah,
none of this,
Drew.
I cut you
off. I apologize.
I should note, nobody should take this as legal advice. You should not get your legal advice from a podcast.
Absolutely.
Absolutely. Drew, I cut you off. I apologize.
Well,
Please.
no. One of the things I was just thinking of here is that when it comes to, how freight brokers are interacting, and in respects to like deep pockets, right? Yeah, they would be viewed as having deep pockets, but so are shippers, right? So you don't want a situation where the shipper and the freight broker have both been pulled into a suit, and the shipper is looking at the freight broker. In other words, you don't want to, when it comes to your shipper relationship, you don't want to overreach there either, right? You want to make your salespeople, they don't want to overreach. You don't want to be in a situation, in my opinion, where the shipper comes back and say, well, we thought, or they sold their services like they were the motor carrier. They told us they were going to be doing things that led us to believe that they were going to be doing some of the things that Brandon just talked about. So I think that that's important as well.
And shippers aren't immune from this discussion either. I've seen lots of shippers
Right.
that impose down on the motor carriers that they tender freight to directly
Right.
all kinds of carrier-like requirements, their own drug and alcohol testing processes,
Right.
their own hours of service rules and stuff like that. As a shipper, you are running that very same risk that we've just talked about a broker running. When you start to do that stuff, you start to look like a motor carrier in your own right, and you start to run the risk of being deemed one and then facing that automatic vicarious liability that stems from the negligence of the driver that you were controlling essentially through all of those things that are more the functions of motor carriers. So shippers beware too.
Yeah, but Brandon, what about, but okay, in this context though, as you said, shippers are not immune as well, right? So you got a situation here where they've been both named, and the shipper comes back and says, well, the freight broker, led us to believe that they were doing XYZ, right? We didn't require them to do it, but they told us that, just for example, that they're going to handle the claim from cradle to grave, right?
Mm-hmm.
They're going to make sure that the motor carrier is operating safely. You as a freight broker, I think you've overreached there as well.
Yeah, but you can see what the shipper's doing, right? They're trying to insulate themselves, and
right.
I think it's an effective way of insulating yourself.
Right.
Probably, I mean, just like we build a house, we put insulation in to protect us from the wind. You
Right.
insert a broker in between you and the motor carriers that are hauling your freight. You've got at least an additional argument to make that,
Exactly.
hey, I wasn't the one that was responsible for vetting these motor carriers. I paid somebody to do it. I was relying on them to do it, and they didn't do it. I think it will be an effective argument. Am I saying that that's going to win the day every case? No, certainly not. But it is certainly something that you see, and you will continue to see probably more and more of down the line here.
Yes.
Well, gentlemen, we have come up to the top of the hour. This has been a great discussion. We definitely have to do this again, but I want to give you each opportunity to do your final thoughts and plugs. Drew, let's start with you.
Well, I would say again, as I've said before, slow it down. Freight's got to move, but slow it down and make sure that your vetting process is thorough. Whatever your SOP is, you need to follow it. So make sure that SOP, fits your operation. If you're going to be using third parties to help you with your compliance, their process needs to mirror. They need to tailor their services to your individual needs. It shouldn't be a blanket type service. It needs to be. You have to ask yourself, okay, how does the things that these people are selling me, how does it fit my individual set of circumstances? I think that's very important. And, again, you need to have those conversations with the motor carriers, insurance agent, your provider's insurance agent, et cetera. I just think that those things are very important. But step one, make sure you have a great, contract between, agreement that you're going to be utilizing your SOP, and you do need to have a qualified, experienced freight transportation attorney to help you do that. Don't do it by yourself. just don't.
Okay, Drew, where can people find you?
They can find me on LinkedIn, Drew Singleton Wilder. You can find me there. We provide, as I said before, we assist people with the compliance on the insurance side and cargo claims if needed.
Okay, Brandon, any plugs, final thoughts?
Well, Drew did a lot of the bidding for me, so I agree with everything he said. And then I'll just reiterate, I think education goes a long way here, and I think brokers and shippers should be taking the time to educate themselves on the Montgomery decision, what it means for them, and also, like I said earlier, what the data that they are now going to be looking at more closely, hopefully, is actually telling them about the motor carriers that they hire, so that they can make informed decisions, is the point. So I'd encourage you to do that. You can follow us on social media. Trucksafe is where you'll find our stuff, trucksafe.com. That course I mentioned is available, trucksafe.com/broker. And yeah, reach out if you have any questions or need any help with these types of things.
Fantastic. Gentlemen, again, thank you so much for your time. Really do appreciate it. There's a lot going on in this industry. There's a lot of moving parts, and a lot still needs to be decided. There are still 50 states that still need to set precedents at their own level to determine how this is going to play out. This is something we're going to be talking about for a very long time to come. We're going to stay with it. We're going to be trying to follow the trends as things go through. And we're definitely going to be watching the fraud as that seems to grow and ebb, depending on how brokers are reacting to this situation. So it's going to be kind of interesting to see how all this plays out. It's a very unique time that we are operating in this industry, for damn sure. Well, ladies and gentlemen, please be sure to check out the Double Broker Bounty Hunter store at vigilanttransport.com. Get yourself a nice mug. Would love to join you for coffee at some point. And with that, folks, your check is on the table. Be sure to tip out your server, and we will see you next week here at the Tic Toc Diner.